Welcome to Jurisprudence. Lesson 32, Legal Formalism versus Legal Realism. But what is formalism and what is realism in this sense? We can only understand them if we see the positions they hold in the scholarship of law. First and foremost, the position held by the legal formalism is that of the positivist thinkers. The positivist thinkers, such as Adolphus Leonis Hart, purports that law and justice should be seen and limited only to the rules. Only those rules, and within those rules, one can deduce what is justice when it comes to the work of the court. The court in this case, according to Hart, is only carrying out the activity of adjudication and the definition of law, but not the interpretation of law. Adolphus Hart, in his system of rules, primary rules, secondary rules, and rules of recognition, is seeing that as self-sufficient, and law does not require another authority beyond itself, or another standard, or another value or ideal. In this case, the position of the formalists is that the judge must apply the law, and the law is rational, and the judge must apply it rationally without any interpretation, any addition, or any removal of the elements of law. That is what we call legal formalism, applying the law as it is by the court in order to administer justice. The position held by the realists is different. The realists believe that law is ambiguous. Law does not define everything, does not tell everything. And in that case, it is the work of the Honorable Court to interpret it in order for it to be understood or to be truthful. The heaviest work of the law and justice is given to the judges in their chambers while adjudicating, while making judgment, and while coming up with the verdict at the tail end of the proceedings. In this case, the judges form themselves what we call stare decisis, stand by the decision, the precedents, the cases. That means they uphold their own opinions. The judges make reference and bind themselves with such opinions, and that make that a judge-made law. That means judges also make law in this form and in this common law system. Any common law system, Anglo-American common law system, whether followed and applied in the Republic of Kenya or in South Africa or in Zimbabwe or in Ghana or in the Gambia, is following the same tradition and the same doctrine of the common law or the case law, if you wish. Our section 32.3, judges are making the law and they bind themselves with those laws. Those laws do not bind upon others who are not officers of the judiciary. And that makes that kind of understanding of law in the formalism understanding as setting up rules in order to come up with some formula to follow or some kind of legal framework that would create parameters and rules for the judges while making and coming up with the laws. But realists insist on the independent formalism in the sense that for the judges to bind themselves with certain rules and judge within those parameters would really make the administration of justice lose in its power to interpret the law. And through the interpretation, the judges, according to the realist school of thought, are also human beings. They have their own influences, they have their own behavior and characters, as well as they can be motivated by some political ideologies. And they may as well equally belong to some kind of spiritual creeds and beliefs. In such condition, the judge has got the liberty of expression or the freedom of expression to express his or her opinion at liberty, bearing in mind his or her experience in the profession of justice system and of the legal practice. By doing so, we move to our section 32.4. In the common law traditions, the doctrine of the stare decisis in the Anglo-American system is simply a question of the realist position. It is the question of the realist position in the sense that the judges have got that freedom and that power vested in the court to administer justice using the interpretation, whereas the formalists put a different argument, and they see that there is a clear distinction between the judge and the law. The judge is just there to apply the law as it is. And given that law is clear, law explains itself, law is rational, judges are assumed to be applying it as it is and to be applying it rationally. What becomes the point of contention here is that the formalists stick to the written law as it is and application of the law as it is, with the assumption that law covers every questions of justice in the society. The realists assume that law is ambiguous and does not cover everything and what human beings need in the society. And in that case, it requires interpretation by the able courts and the competent judges. Let us see our learning experience here, our learning outcome. Under section 32.7, our learning outcome number 1 is that common law tradition of the judicial practice is that of the judge-made law. That means it is the judge with the power to make decision and to make a binding ruling. And that binding ruling is informed by the experience of the judge and the capacity of the judge, apart from just adjudication, but also the interpretation of the law. Legal formalism, under number 2, serves a very important purpose to come up with the check and balances of the adjudication and the administration of justice, in the sense that the judges cannot also be assumed to having everything in order to come up with the justice without being guided by certain principles and certain legal parameters in which they apply the law. They detect and approve that there is a breach before they impute such breach upon the accused. Number 3, we see that the integrity of the system relies so much within the antagonism between the formalism and the realism understanding, because there must be an embeddedness of both. In some cases, maybe there may be so much of formalism and less of realism, or so much of realism and less of formalism. But all this is a case-by-case analysis that can take us up to considering other cases. Thank you for watching, and bye for now.